Before we start talking about bankruptcy, and if anyone is still joining, I thought I would just give a very brief outline of what we are intending with the King's Young Professionals concept. Our intention for these events and seminars is as a way of us, the more junior members of King's Chambers, me, very junior, Laura, a little bit less so, but really for us to connect with solicitors and professionals at all levels, but perhaps pitch towards and with a particular eye towards those of a similar level of experience to us. So our peers both now and of the future. That said, they are, of course, in no way exclusive. Professionals of any age are very welcome, and we very much hope that the content will be useful for anyone. So without further ado, as you all know, today's topic is an aspect of personal insolvency, namely annulment and rescission of bankruptcy orders. Now, I think this is an interesting topic because they are neither particularly common nor particularly rare. There's a lot of case law on them, and many of you, I'm sure, will have come across a situation where either you have a client who's been made bankrupt and wants to know if there's anything you can do about it, or you might act for a creditor of a bankrupt or a trustee who's having to respond to one of these applications. But they're all quite unique. And so I think taking a step back and going back to basics, as the topic promises, can sometimes help to put everything in context. Now, because of the time available today, this really cannot be anything more than an overview of the key features. We'll provide some practical tips, the headlines we've given you in the blurb for this topic, which are also there on the slide. We expect to be around 30 minutes and maybe a little bit more, maybe a little bit less. And then we hope there'll be about 10 minutes at the end for questions. But needless to say, it's always very hard to make this not sound too much like a pitch, but our email addresses will be at the back of this presentation. So if you do have any further questions or there's an aspect of this area that we haven't covered, please do feel free to get in touch. So because we don't want to take anything for granted here, Laura, in headline terms, what is an annulment or rescission of a bankruptcy order?
Thanks very much, Nick. And if we can do the process, next slide, please. So annulment versus rescission, they are similar, but very much also different. An annulment under Section 282 of the Insolvency Act treats the bankruptcy as if it had never been made. And so the bankrupt reverts to the pre-bankruptcy status, which is obviously particularly beneficial if that's possible to be achieved, better for credit, having removed from the credit file, etc. Whereas a rescission is not quite as good under Section 375(1) of the Insolvency Act. That terminates the bankruptcy at the date of the rescission. So really that's looking for terminating the bankruptcy early, but it's likely you're only going to be going for a rescission if there are no grounds for an annulment, because that would give the bankrupt a better result. I won't tread on Nick's toes as to what the grounds are, but you'll come on to see that they are different. Just in some headline terms, though, if we can have the next slide, please, Nick, just to try and again set in context the difference. The Court of Appeal case in Young against Official Receiver considered these differences. An annulment is on the grounds existing at the time of the making of the bankruptcy order. The order ought not to have been made. Whereas rescission is where the underlying liability on which the bankruptcy order is made is subsequently set aside. So the distinction there in that case was a disputed council tax payment where it hadn't been paid. There was a liability order to pay the council tax. Whilst that was wrong and it never should have been made in the first place, at the time the bankruptcy order was made, it existed. So it wasn't possible to say that that the bankruptcy order never should have been made at the time, only that it could be rescinded because the liability eventually wasn't there when it was found and determined that actually the council tax amount wasn't payable. So it sounds like a slightly unfair result there for Yang, but that's a really useful case if you're not sure about it to drill down into basics. And again, as I say, I don't want to step on Nick's toes too much in going into the detail, but that's a useful case to highlight the differences and how it can seem a little bit unfair, but ultimately sticks very strictly within the wording of the Act, which is what is necessary here rather than previously would have been looking at inherent jurisdiction points.
Yeah. So I think that's a really helpful overview as to what the application can do for you, or your clients, I should say. But in practical terms, Laura, when should you make an application for annulment?
In terms of making an application for annulment, timing we'll come on to in just a moment, but in terms of the legal effect, just to pick up a little bit further on that. Now, an annulment, and I've quoted the act there, I won't read it out to you, but as I say, it's someone being put back into the position that they would have been if the bankruptcy hadn't been made. So essentially it's saying that anything that's vested in the official receiver or trustee revests in the bankrupt. In terms of the legal effect of the rescission, if we can just go on to the next slide, because that only brings the bankruptcy to an end, that's going to be much more fact specific rather than, as you can see with the previous slide, we've got the statute there telling you exactly what's going to happen. In terms of rescission, it's going to depend on what the situation is. And for example, if there are any undertakings that are in place already, or if there are any bankruptcy restriction orders, they can still be made, they can still exist, and you're going to need to make an application to have those lifted, separate purely to the rescission if they're in place and if there are grounds for having those lifted, which one would hope if you're getting a rescission there would be, but that may not actually be the case. So you're going to need to look at that on a case-by-case basis.
Yes, so I did jump ahead a little bit, but in terms of timing, then it's what is the practical advice on that, I suppose?
Practical advice there is as quick as possible.
Yeah.
There aren't any limitation periods or time limits that are applicable, but in terms of whether either of these options are going to be granted, you need to act promptly. Now, Taylor is the key case on that, and that looked at a 12-year delay with all sorts of procedural delays in the meantime. And there it was said that promptness is a factor in the court's discretion, and it's a big factor there. In the Taylor case, it was said, well, this has already been a very expensive, long-running process, and taking it any further in terms of an annulment there was only going to lengthen the process and make it more costly. You can also see there from the Gill against Quinn case and Rule 10.136 of the insolvency rules, there's sort of practical reasons why delay is a factor. So Rule 10.136 there refers to the ability to give notice to creditors who have not proved in the bankruptcy already. And if there's been a passage of time, that's going to be harder to do and to get an appropriate result from. It's also going to mean that there's a chance that documents have been destroyed. We know in all areas of practice that's a problem with GDPR these days. And so that sort of feeds into why delay is such an important factor here. Now, it's not the only factor, and I'm sure Nick's going to come on to some of the discretionary points. But as I say, that is a key issue there. Now, and I hope this doesn't tread on Nick's toes too much with some of the factor points, but it's also going to be relevant in terms of an annulment application, whether the delay also overlaps with whether actually there were arguments that were there in the first place which could have been run and which weren't, and therefore whether any other party in the proceedings are going to say, well, actually this is abusive to be raising these arguments at a later stage. So as I say, I don't want to tread on Nick's toes too much in that, but in considering the timing of when you're making the application, look at what's already been raised, look at what you knew at the time, and are there arguments to say, well, actually, in this time, these circumstances have changed in terms of how we understand this point or what its relevance is. And when you're making the arguments in the first instance, obviously try and explore all options there, because you don't want to be faced with this argument that it's abusive to be raising them at a later stage if it was possible earlier. And considering the court's discretion here, coming with the most realistic and straightforward solution, again, means it's probably well worth bearing that in mind. So in terms of rerunning arguments, that's potentially also going to be abusive as well, and that's something you want to look at in terms of the timing and what's available to you to make as an argument, and whether you can, again, as I say, extend that to say that something has changed in the meantime, even if there's scope for saying that there was an argument to be made previously. But as I say, promptness is the key factor, and then consider all the other discretionary factors that might appear to be relevant in the background. So that deals with what they are, what the legal effect is, and when you should be making the application. Now Nick's going to deal with the actual tough stuff. So Nick, what are the actual grounds for making these applications? And can you tell us a bit more about the difference and when you might want to follow one route or the other?
Yes, of course. So we know, I suppose, now what they are, what they do, when you might want to do it. But I suppose the meat of it is, how do you actually go about doing it? What grounds might there be for an annulment? So let me just move on. And I'm now talking more about annulment because I'm referring to the express statutory test. But unless I say otherwise, I would assume that it's safe to say that these considerations would also potentially be relevant to a rescission application. There is also overlap. Laura's already touched on what the differences are, and I'll come back to those just to reiterate it, because I think the differences are important and it's helpful to have them clear in your mind. But for now, let's just think about annulment. So there's three statutory grounds which I've put on the slide there, taken from the Insolvency Act 1986. In very brief terms, the first is the bankruptcy order ought not to have been made. The second is that bankruptcy debts and expenses have all been satisfactorily paid or secured. The third is that an undischarged bankrupt has made an IVA with their creditors. Now, the first two, as Laura's already referred to, under the section 282, are discretionary. The language is that a bankruptcy order may be annulled if either of those criteria are satisfied. And as Laura has mentioned, one of those factors in the exercise of discretion is promptness, as that can go to many things, not least prejudice to creditors who already exist. The third ground, the section 261 ground, that's in fact mandatory. So if there is a conclusively established IVA, so in other words, the period for challenging the IVA has expired and there are no outstanding or appealable challenges to that IVA, then a bankruptcy order will be annulled on the application of the bankrupt or the official receiver. Now, because that last ground is quite straightforward and you'll generally know it when you see it, I won't say much more about that one, and I will just focus on the first two because they, certainly in my experience, tend to be a little more common in practice. So the first ground is that the bankruptcy order ought not to have been made. Now, I might be wrong on this point. Someone might be able to correct me, but I would suspect that in practice, this is probably most common form of application. And when making an application of this type, you often hear of the Keckman test as a formulation of this ground that the courts will like to work through. It's taken from the High Court case, which is there on the slide. Now, with the greatest of respect to Mr. Justice Morgan, I'm not sure that the Keckman test is necessarily rocket science, but I think it does helpfully focus the mind on perhaps how to approach an evidence, an application under this ground. So, for example, for any witness statements supporting an application, if they can be drafted with the first limb comprehensively and squarely in mind, and perhaps even address the second limb, if not overly submissions focused, that can really help any application that's made. So that three-stage test is something that the court will have in its mind when approaching an ought not to have been made type application. So here are some examples of when a bankruptcy order ought not to be made, some more obvious than others. I'm not going to read through that list, but you can see them there as probably the most, well, I say the most common examples. I've put them in what I think is a very rough order of commonness. But the last three in particular, I would suggest or suspect, are either very fact specific, and you'll know them when you see them, or perhaps very rare and don't come up very often in practice at all. But certainly the first three in particular, I would have thought would be quite common, especially for clients who have perhaps been unrepresented at their bankruptcy hearing, and so might not have known the arguments that could have been deployed in their favour at that hearing. So, for example, the fact that the petition debt could have been disputed or could be disputed is likely to be a very common ground which might found an application for an annulment. And if an application is made on that basis, the test on an annulment application, where that ground is asserted, i.e. the petition debt is disputed, is essentially the same as for an application to actually set aside a statutory demand, i.e. There must be substantial grounds for disputing the petition debt, but the bankrupt does not need to go so far as to show that the petition debt is not owed at all. I think the first two are perhaps, the other first two of the three are perhaps a little bit more self-explanatory. Now, I think Laura's already touched on this, but some questions might arise from that sort of consideration, which is, for example, what if the petition debt was disputed at the bankruptcy hearing and that challenge was dismissed? Could an annulment application be used to relitigate that ground? Well, as Laura says, yes, but really only in very exceptional circumstances. And Laura's actually already mentioned another example of this case, but, another example of this outcome. But the case of Cranmer, which I put on the slide there, is I think another good example of what I would describe as quite common Pyrrhic victories for bankrupts in these sorts of applications, as after successfully appealing their application for an annulment all the way up to the Court of Appeal, the bankruptcy order was set aside. So on the face of it, a victory, but on the condition that the bankrupt pay all of the trustees' costs and pay all the unsecured creditors. Now, this got to the Court of Appeal, and the application was many years after the bankruptcy. So I'd query whether or not the bankrupt was really ever going to be able to satisfy that condition, and so whether or not much was achieved here other than us having a good case to talk about. What about new evidence that could be put before the court that wasn't there at the time of the bankruptcy order? So as we're talking about an annulment here, just for now, this must be evidence as to facts that existed at the time of the bankruptcy. Otherwise, we're in rescission territory for reasons which I'll come on to again in a moment. And again, this might be quite common if the bankrupt did not get their ducks in a row evidentially for the bankruptcy hearing. Perhaps again, they were unrepresented and didn't know what they needed to do. But if they're now instructed solicitors and have gathered the evidence that could have supported the challenge to the bankruptcy order, will the court look at or consider that evidence? Well, again, the guidance in the case law indicates that yes, this will usually be considered by the court, at least to some extent, at an annulment application, principally because the court, if it doesn't do so, might open itself up to a successful appeal on the basis of a serious procedural irregularity. It's advisable, I think, to explain why the evidence wasn't before the court on the first occasion, but I would certainly say that don't be afraid of putting it in there. So that deals with the first of the main grounds, ought not to be made. The second is that the bankruptcy debts have been paid or secured. I will be a bit more brief with this one because really the clue is in the name. It's, again, generally more straightforward as to know whether or not you've hit this test. But there are a couple of practical points to note here, which I think are of interest. The reference to debts in the language is to debts that the creditor or creditors have proved in the bankruptcy. So if there are known to be non-proving creditors, what will often happen if this hasn't been done at the date of the hearing is that the court will essentially order the trustee to advertise or give notice to the creditors to require them to prove their debts within a certain period of time, and then will adjourn the hearing of the application until after that time. And then if the non-proving creditors still haven't proved their debts, then the court can, if it wishes to, and if it's otherwise satisfied, ignore their claims and go on to annul the bankruptcy. There are other considerations here. For example, if a creditor can't be traced, then the debtor may have to provide security, for example, payments into court to satisfy any debt which might subsequently be proved. And I've said there that you'll sort of know it when you hit it, but the court will still retain a discretion. Laura's already touched on this case of Gillian Quinn, but it's a good example of where actually the applicant had advertised and had sought to find out all the creditors, but because there was a serious delay in making their application and actually a lot of documents had been lost, it's very difficult to establish who had been proved, who had proved in the bankruptcy and who hadn't. And so the court declined to exercise their jurisdiction. I gather essentially the court was cautious that the bankrupt may achieve something of a inadvertent windfall by having their bankruptcy annulled, where it was so unclear as to whether or not creditors had approved. So that's the second ground. And the third one, as I've said, is more straightforward and I won't touch on in more detail. So what's the difference between annulment and rescission? Well, as I've said, there is firstly potentially a lot of overlap. Rescission under section 375 is really relying on more of a general power of the court to review, rescind or vary orders made in bankruptcy. So if for some reason you had only applied to rescind the bankruptcy order without any reference to the annulment provisions, in all likelihood, the court would no doubt have reference to those provisions and the guidance in that respect. And when we talk about the difference here, for reasons that will become obvious if you're not already familiar with them, the difference only really relates to the first annulment ground. So that's the ought not to have been made ground. And the key difference to have in mind is this. With an annulment, the grounds for annulment look at the situation and the facts that existed at the time the bankruptcy order was actually made. So if your evidence in support of your annulment application refers to things that happen up to and including the date of the bankruptcy hearing, really that's more likely to support an annulment application, and that's the territory you're in. With a rescission, you can also take into account changes that have occurred since the bankruptcy order was made. So if your evidence is referring to post-bankruptcy events, that is more likely to be a ground for rescission. Now, that difference can sometimes seem a little bit cryptic without any context, but it's, I think, helpful to give an example. Laura's already referred to the case of Yang and the official receiver. I've cited the High Court decision of His Honour Judge Hodge QC showing local bias, but this is in reference to council tax liability orders, which, as Laura says, these are a species of debts which, if it exists at the time of the bankruptcy hearing, and there's no outstanding appeal or intention to lodge an appeal in respect to this order, they can quite properly found a bankruptcy order, as they very often do. But if the council tax liability order is later set aside, that is a ground for rescission, because at the time of the bankruptcy order, the debt was valid and enforceable, and it was only after the bankruptcy that it was not. Tax, I think, is actually probably quite a common example, or good example of this distinction again. So to give another example, really just to hammer the point home, I think, with VAT returns for a sole trader, essentially it's the filing of a return and then also the payment of the liability that constitutes discharge of the VAT liability from HMRC's perspective. So if you say the amount stated on the VAT return is paid, but for whatever reason, say administrative error on part of your accountant, the returns are not properly filed, if that somehow got to the point where the sole trader was made bankrupt on the petition of HMRC, but the VAT returns were filed and suddenly HMRC reassessed what was owed down to below the statutory limits, that in my view would support rescission. The bankruptcy order at the time of the order was properly made. It's only events after which show that it warrants rescission. So just a couple of other points to pick up on before giving you some more practical advice. In terms of standing to make a bankruptcy annulment application, obviously it's normally the bankrupt, but it actually doesn't have to be. Anyone can apply for a bankruptcy annulment, provided that they have a legitimate interest in the annulment. So an unfortunate but more common example of this would be a divorcing spouse who might believe that the bankruptcy application, often made by the bankrupt themselves in this situation, was designed to thwart the divorce proceedings and ancillary relief. In terms of the burden, who has the burden on making the application, Again, in the vast majority of cases, it's on the bankrupt. The burden is on them, but that burden can actually switch. So, for example, where the bankrupt themselves petitioned for their own bankruptcy and there is evidence that they were actually solvent or dishonest at the time. So in those circumstances, the burden is actually usually on the bankrupt for them to show why the order should not be annulled, because often in that situation, it would not be in their interest for the order to be annulled. So some practical tips. As Laura said, apply as soon as you have the evidence ready to go. It is so much easier if delay in applying is not a factor that the court has to give much consideration to. If there is a delay, I think it's best to acknowledge it head on and try to explain the reasons for it. Annulment applications are sometimes made many years after the bankruptcy order, and there's no reason to believe that they're always going to be hopeless on that basis. That said, the witness statements and evidence in support of the application is, as ever, absolutely key. And because it's so important, don't be hasty in putting it together. So don't delay, but equally don't rush the process. Make sure that all the evidence you have is there and as strong as possible. So as you'll have gathered from this talk so far, there are a number of roads which can lead to the same outcome, a number of grounds on which an application could be made for annulment and or rescission. And it is sometimes legitimate to try and go down different roads in the same application in the alternative. And as Laura said, it's indeed often better to do that in the same application than trying to make perhaps a later application on a different basis and risking arguments as to abuse of process being opened. So obviously, in respect to this step, I've got a vested interest, Laura's got a vested interest, all of us here in the King's Young Professionals Group have a vested interest, but this is, I think, the source of application that does perhaps benefit from early input from counsel, perhaps carrying out a review of the witness statement. There is, as you've seen, a lot of case law in this area, which has provided a lot of guidance. I think really there's no application in this area that's cookie cutter, and it can sometimes be helpful to have a pair of eyes to look over it and give you a second opinion as to how a judge might view it. The final piece of practical advice I've got, and this brings me on to my next question to Laura really, is have a plan for costs and discuss these with the client at an early stage. So if you assume that your application is going to be successful for reasons which Laura is going to explain to us, the bankrupt's troubles are probably not necessarily over, and costs can often prove to be one of the difficulties in these sorts of applications. So Laura, on that, what do I mean by that? And what's the usual position and considerations for costs where an application is successful?
Thank you very much, Nick. Apologies whilst I just close that screen. So costs, wide discretion here, and it is going to be fact sensitive, and it's likely that one of the facts that's going to be relevant is going to be any delay in progressing matters, and without bearing in mind the time going into too much detail, that can lead into issues of interest and how that's treated, how quickly matters are dealt with, and there are all sorts of reasons, even just looking back at the Yang case, why a judge may or may not exercise their discretion in a particular way in terms of costs, in terms of how someone's got to a particular position, particularly with annulment, or as in that case where the annulment versus rescission position seems particularly or potentially challenging. One of the main concerns is going to be the position of the official receiver or trustee and them being paid. And that's going to be a key, not necessarily starting point, but a key consideration in terms of costs. And so I think Nick's opening gambit of have a view on this and have a plan on this right from the outset, given the wide discretion, is going to be a good idea. And that comes back to my earlier point on timing in terms of what arguments have run and when. And it may be, for example, if you have some new grounds to argue, but you also want to try and shoehorn in some old ones, you decide, well, actually, that's not going to help you in terms of the discretion on costs. So you might decide not to run that point, thinking ahead to the conclusion of matters and what's going to be that position at that stage. Now, in terms of some other more general points to think about in terms of the discretion, if we just look at that final point there, it's also worth thinking about where does this get you to? So if you've managed to persuade the court to exercise its discretion and give you what you want, and there are costs that are going to be paid as a result of this, it may be in a rescission situation that there's going to be a rehearing of the bankruptcy, and it's not going to weigh in your favour if you haven't paid the costs before getting to that point. Now, if we can just go on to the next slide, please, Nick. Some of the concerns in terms of payments for the trustee or the official receiver, and it's very much overlapping here whether you're looking at annulment or rescission in terms of the principles. The facts you might want to argue in terms of discretion may well be quite different, but these sort of general wide principles are going to be relevant. And so depending on where you're coming at this from, in terms of whether something shouldn't have been granted in the first place, or you're looking at different grounds, can depend on which starting point you're at there. And there's the relevant case of Butterworth and Souter to look at and consider as a starting point, albeit some of the case law says that there aren't essentially any set principles in this area, and you're looking at that starting point of the wide discretion. Another point, whilst we're trying to sort of broad brush this, that is worth bearing in mind is that even after the annulment, the bankrupt can still challenge the trustee's costs, and there's some case law there in the Hirani case to support that. And again, that's going to be worth bearing in mind right from the outset as to what battles you pick and at what particular stage, as I say, bearing in mind all of these points on discretion. Now, in terms of just some other examples of what might be considered in terms of costs, for example, in an annulment situation where the bankrupt has been the victim of a miscarriage of justice, in terms of the petition debt having been procured by a fraud and it was not properly payable, even in those sorts of circumstances, that was the case where the Court of Appeal determined that there still had to be payment of the trustees' reasonably and properly incurred costs. And that was the case of Okari and against Dean and Defty, which is a 2013 Court of Appeal case. And I think that really properly highlights that whilst there is a wide discretion on costs, that shows how much weight and concern the court will give to the costs of the trustee or the official receiver, even where that was a objectively very harsh result for the bankrupt as a victim of a miscarriage of justice, but it can give some reassurance to office holders that in terms of these applications, it's not going to be them that suffer in terms of costs. Now, I think, as Nick says, it's really a practical question of looking from the outset and seeing what arguments you're going to make. But that, I think, shows the one principle that we can hang on to in terms of costs and what's going to be the result. And that may, again, be a consideration for what are going to be the official receiver's costs, how are you going to pay them and when, to decide, again, what points are taken as you pursue these matters. So it's a pretty wide area. Again, it might be fair to say that it's something worth looking at as a team approach right from the outset. There's an awful lot of case law on these principles. And when you're looking at a wide discretion, that's when we want to look at what are the best arguments we can run and potentially the ones that aren't worth taking. Just as another example, if you bear with me. As I say, the case law that we've cited there, it's going to be relevant in terms of annulment also, but you might find if you've managed to satisfy the more challenging arguments there, that the discretion can weigh more greatly in the bankrupt's favour in terms of limiting what's going to be paid more widely on these points, but it doesn't seem that it's going to change the position, particularly for the trustee or the official receiver. So that's a pretty broad brush answer, but safe to say, unless you're asking us about specific cases, it's somewhat challenging to say much more than that in terms of costs. But knowing that there can be a challenge to the costs at the end of matters, I think is somewhat heartening for the bankrupt to know at that stage. Now, that's a whistle-stop tour within the time that we've had available. And we've had a couple of questions come in, and if anyone has any further questions, then feel free either to put them in the Q&A or in the in response to our emails, which I think are just on screen now. Now, in terms of the questions that we've had so far, we're asked, can the court make conditional annulment orders? Nick, what's your understanding of whether they can make conditional annulment orders, considering the sort of strict parameters in which you can be making an application like that?
Yeah, well, I think we've seen a couple of examples of where essentially the court does make effectively annulment orders, which are conditional on various things. So I forgot the name of it, but I think the Crammer case was an example where actually the annulment application was successful, but conditional on the bankruptcy was being set aside, conditional on the trustee being paid, creditors being paid. So yes, and the court has a lot of discretion, as we've heard, and a wide range of powers in this area, and will often craft the remedy and the order so as not to injustice any particular creditor, official receiver, office holder, anyone affected, because obviously a number of people and parties can be affected by annulments. So hopefully that answers that question.
Yes,
Laura,
just on that, Nick, do you think there's sort of a situation where it could be that there's a decision made that it's appropriate to annul the bankruptcy, say, for example, procedural circumstances, but the debts haven't actually been paid in advance. And so there's concern there, and there needs to be essentially an undertaking to pay. As I understand it, it could be possible in that situation to say, well, there's a date in future when the annulment will take effect if the debts and expenses have been paid in full. That seems to be the sort of, I suppose, practical and proportionate way of dealing with it if there's still a concern at the time of the hearing that would hopefully satisfy all parties.
Yeah.
Okay, and then in terms of the second question we've had, is a disposition automatically void under section 284? If so, why does a trustee have to make an application to court to recover property transferred as a result of a void disposition? Now, here, do you think, Nick, it's potentially going to be different if you've got an annulment or a rescission? Because if you've got a situation where there is a void disposition whilst the bankruptcy was live and the rescission brings that bankruptcy to an end at the date of the rescission, would that seem to be different as compared to an annulment where you're saying, well, the bankruptcy never existed in the first place?
I think you've sort of hit the nail on the head, really. But I think I'm going to essentially bounce one back to you, Laura. This is more your area, if that's okay.
Well, it seems to me that it's, as we said right at the outset, the sort of more straightforward but harder to achieve point of the annulment versus the more fact-specific situation of the rescission, where potentially you're going to be making other applications to lift any undertakings, for example, that might be in place at the time. So if you annul, then the property is going to revest because it ought to have been that the bankruptcy was never made in the first place. And it strikes me that's the way for that to be achieved, that even if there is a situation where there's been what appeared to be or was determined to be a void disposition in the interim, or potentially there's been an application and that's not been determined, I can't see how that could stand when the property revests. But if you've got a bankruptcy that existed for a period of time and then is rescinded, it does seem to me that that's likely to be, and I know that's somewhat couched, but it seems to me that's got to be likely to be a situation where, as part of applying for the rescission, you'd be making the necessary application at that time to say, no, actually, this is not a void disposition, or if there's an application outstanding, getting that withdrawn, or having that determined that no, it's okay at that stage, in order to make sure that the necessary steps are taken. So it seems to me that's quite a useful practical answer to sort of draw out what would seem to be the distinctions there, as best I can tell you, in the circumstances at this stage.
Yeah, no, I think that's very true, and it will often depend actually on what the obviously out of context. Sometimes it's difficult to answer, but when you're looking at a specific transaction or something of that kind, and what the likely outcome of your application might be, especially if perhaps you've made an application that seeks annulment or rescission in the alternative, it is perhaps another practical tip is to think, what do we need to look at here in terms of dispositions and transactions and other things that have occurred? And if we are successful, what do we need to then do to deal with those? But yes, I've nothing really else to add to that.
Okay, well, we've gone 1 minute over our 40-minute timing, so I'm going to take that as a win in terms of delivering seminars, and I hope people have found that useful. As I say, and as Nick mentioned, you've got our email addresses there. Feel free to get in touch if you've got any further questions, or of course you can always get in touch with our clerks as well at Chambers. We welcome any feedback. We will, as Nick says, be continuing with the King's Young Professionals Network. So if there are any particular topics that you'd find useful, or indeed if you're a bit more senior and think there's something in particular that you always identify, maybe with trainees and junior solicitors and insolvency practitioners, that you think would be particularly useful for us to talk about, please feel free to give us that recommendation, and we'd be very much happy to have your input on that. Yeah. So thank you very much for attending this evening. I think we've recorded, so if there are any, sorry, seeing some chat come in. So if there are any people that would like the recording, I'm sure you can get in touch with Katie, or it may well be sent out. Otherwise, Nick, if I hand over to you just to close things finally.
That's fine. This is my biggest challenge of the night, I think, is stopping this. But thank you all very much, and hopefully see you again at the next event. Thank you.